Hi, it's Roland Jones. This is a short video and a series of short videos on preference and fraudulent conveyance issues. This case deals with a motion for summary judgment in the context of a fraudulent conveyance case, Redmond versus NCMIC Finance Corporation from Kansas. The facts are a little bit complicated. The debtor, a Brook franchise, is a franchisor of insurance companies. Essentially would make payments on loans supposedly based on commissions earned by the sale of insurance companies, but actually Brook franchise used other funds to pay these loan payments. Brook franchise went bankrupt, trustee was appointed, trustee sued one of these recipients of these loan payments, one of the lenders that received payments, alleging that these were fraudulent conveyances. The defendant filed a motion for summary judgment, contending that that the transfers were received in good faith, and that the defendant provided reasonably equivalent value. So the issue is, were the transfers received in good faith, and was there a reasonably equivalent value? And a summary judgment, can summary judgment be appropriate in this situation? This relevant statute for the substantive law part of this is 548A 1A, where the payments made with intent to hinder, delay, or fraud. 1B, A1B, where they received was less than a reasonably equivalent value transferred in exchange for such payment. Is can that be gotten rid of? Can this action be gotten rid of by summary judgment? The court found that there were, not surprisingly, that there were factual issues. Factual issues as to good faith, whether the lender should have noticed that there were issues with this company, that there were irregularities, should it have inquired further. So, did it just, did it turn a blind eye, basically, and just take the money and run? The court noted one of the facts in the case, that the lender didn't review the SEC filings, which would indicate some kind of an issue with the debtor. Additionally, the court shot down the defendant's argument that there were no red flags, and that the court should only focus on what the transferee knew. The court stated, no, that's not good enough. It's not what you knew, but what you should have found out, what you should have known, and not only what you knew, as part of the good faith inquiry. So it's not, in other words, you can't just submit an affidavit. There's no fact issue. We didn't know. Not good enough. It's what you should have known. What kind of inquiry did you do? And that's a fact issue. The court found it can't be dismissed. It can't be resolved by summary judgment. Additionally, in the context of this complicated scheme, the court did not find that it could grant summary judgment even on the equivalent value argument, and that's a material fact as well. Since the defendant did not show the absence of material disputed facts, the summary judgment motion had to be denied. This case, the takeaway here is that courts are really reluctant to dismiss cases on motions for summary judgment if there are clear fact issues in the way. Fraudulent conveyance cases are notoriously difficult to resolve on summary judgment. That's why all cases are mostly settled, but or rather, most cases are settled. but fraudulent conveyance cases in particular. Why? Because uh, did someone have good faith? Maybe that can be shown. Maybe that burden can be met with an affidavit, but it's basically a fact issue. And also, valuation is almost always a fact issue. What was the value that was given in exchange for the transfer? It's often a typical fact issue, and these things are just not going to be resolved by summary judgment most of the time.